Getting some breaking news out of Washington. Eamon Javers has that for us from the White House. Eamon?
Scott, that's right. We've got a decision here from the Supreme Court on Rebecca Slaughter at the Federal Trade Commission. The Supreme Court in a 6-3 decision indicating that President Trump may continue to fire Rebecca Slaughter even as the court considers her case. They say they're going to have hearings on this in December of 2025. But for now, the president is authorized to remove Slaughter.
Okay, so what just happened in federal court is absolutely insane. And honestly, it might be the moment that seals Trump's legal fate once and for all. We're talking about a dramatic federal hearing on November 15th, 2025, where Trump-aligned witnesses literally collapsed under cross-examination after special counsel Jack Smith dropped what can only be described as a bombshell evidence package that nobody saw coming. I mean, we're talking about insider notes from Trump meetings, deleted surveillance footage that was recovered through digital forensics, authenticated recordings of private conversations where Trump allegedly admits he knew what he was doing was illegal. This is the kind of evidence that prosecutors dream about and defense attorneys have nightmares over. And the witnesses, these people who had previously given sworn testimony supporting Trump's version of events, they completely fell apart on the stand when confronted with this evidence. Some of them reversed their prior testimony entirely. Some broke down crying and emotionally admitted they'd been lying. And Trump's legal team was left in complete disarray, trying to figure out how to salvage a defense strategy that just imploded in real time. But before we go any further, real quick, let's be honest, you can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us. Be part of the community that actually cares about the truth. All right, let's get back to the video.
From the Federal Trade Commission. The Supreme Court is going to take this case up, though, and they're going to look at this issue of what's called Humphrey's executor. That is the precedent that sets up this idea of independent agencies. A lot of folks inside the Trump administration have been pushing to see if they can get a ruling from the Supreme Court abolishing Humphrey's executor and giving the executive branch a whole lot more control over a whole raft of independent agencies, including the Federal Trade Commission. For now, though, what the court is saying is that Slaughter can be fired while they move ahead with this case, and they go ahead and consider it in December. Scott, back over to you.
All right. Eamon, thank you. Eamon Javers.
Let me set the stage for you, because the context here is absolutely critical to understanding why this hearing was such a devastating blow to Trump's legal position. Special counsel Jack Smith has been investigating Trump for months on multiple fronts. We're talking about election interference related to January 6th and efforts to overturn the 2020 election results, obstruction of justice related to classified documents found at Mar-a-Lago, and potentially other crimes that haven't been fully disclosed publicly yet. Trump's entire defense strategy up to this point has relied heavily on witness testimony from people close to him who claimed they were present for key events and conversations, and who insisted that Trump didn't do anything wrong, that he genuinely believed the election was stolen, that he had authority to keep classified documents, and that there was no criminal intent behind any of his actions. These witnesses were supposed to be Trump's shield against prosecution, the people who could testify that everything he did was above board and legal, and that prosecutors were just twisting innocent actions into something sinister. But during this November 15th hearing, that entire defense strategy just collapsed like a house of cards, because Jack Smith came prepared with evidence that systematically destroyed the credibility of every single one of those key witnesses. We're talking about a massive evidence trove that Smith personally handed to the judge: documents, recordings, digital forensics reports, everything meticulously organized and authenticated. The insider notes alone are apparently devastating, because they show what Trump was actually saying in private meetings when he thought there were no recordings and when he believed he could speak freely without it becoming public. These aren't secondhand accounts or hearsay. These are contemporaneous notes taken by people who were actually in the room during critical conversations where Trump was making decisions about classified documents and election challenges. The recordings are even worse for Trump, because you can't argue with someone's own voice saying things that directly contradict their public statements and legal defenses. The deleted surveillance footage is particularly significant because it goes directly to the obstruction of justice charges related to classified documents at Mar-a-Lago. Apparently, there was security camera footage that showed people moving boxes of documents around, potentially in response to subpoenas or search warrants, and that footage was allegedly deleted in an attempt to hide what was happening. But here's the thing about digital evidence. When you delete something, it's often not actually gone. It's just marked as deleted and can potentially be recovered by forensic experts if they get access to the devices quickly enough. Jack Smith's team apparently had digital forensic specialists who were able to recover at least some of that deleted footage, and what it shows is apparently so damaging that when witnesses were confronted with it during cross-examination, they had no choice but to admit their previous testimony wasn't accurate. You can't argue with video evidence of yourself doing something when the video is right there being played in court. What makes this hearing even more dramatic and significant is how the witnesses reacted when they were confronted with all this evidence during cross-examination. These weren't just minor adjustments to their testimony or small admissions of memory lapses. We're talking about people completely reversing sworn statements they'd made previously, breaking down crying on the witness stand, and in some cases explicitly admitting that they had lied in earlier testimony. That's absolutely catastrophic for Trump's defense because once witnesses start admitting they lied under oath, their entire credibility is destroyed and everything they've said becomes suspect. Defense attorneys live in fear of this exact scenario where their key witnesses get caught in lies during cross-examination because there's really no way to recover from it. The jury or judge is sitting there watching someone admit they lied, and from that moment forward, nothing that person says can be trusted. The judge's reaction to all this evidence is incredibly telling about where this case is headed. According to reports, the judge called the evidence package that Jack Smith presented outcome determinative, which is legal language that basically means this evidence alone could decide the entire case without needing much else. That's an extraordinarily strong statement for a judge to make because judges are usually very careful about not telegraphing how they're leaning or what they think about the strength of evidence before all the facts are in. When a federal judge looks at evidence and says it could determine the outcome of the case, that's about as close as they'll come to saying this looks really bad for the defendant and the prosecution has built an extremely strong case. It suggests the judge believes this evidence is so compelling and so directly relevant to the charges that it potentially overcomes any reasonable doubt about Trump's guilt. Trump's legal team was apparently completely unprepared for the witnesses to flip like this, which raises serious questions about how well they've been managing this case and communicating with their own witnesses. In a well-run defense operation, attorneys maintain close contact with their witnesses, prepare them extensively for cross-examination, and make sure everyone is on the same page about what the testimony is going to be. The fact that these witnesses apparently surprised Trump's lawyers by reversing their testimony suggests either the lawyers didn't know their witnesses had been lying, or they did know and hoped they wouldn't get caught, or there was some breakdown in communication and preparation. None of those options reflects well on the defense team, and it creates this sense that Trump's legal situation is spiraling out of control with lawyers unable to manage even basic witness preparation. The connections to January 6th planning and the Mar-a-Lago classified documents situation make this hearing particularly significant because it ties together multiple different investigations and potential charges into one coherent narrative of criminal conduct. The evidence apparently shows that Trump knew his actions regarding the election were illegal, that he understood he didn't have authority to keep classified documents after leaving office, and that he took active steps to obstruct investigations into both matters. Those recordings where Trump allegedly admits he knew what he was doing was illegal are absolutely devastating because they destroy the good faith defense that his lawyers have been trying to build. You can't claim you genuinely believed you had authority to do something if there are recordings of you admitting you knew it was illegal. That's about as clear-cut as evidence gets for establishing criminal intent. So let's dig deeper into what this evidence actually shows and why it's so devastating to Trump's legal defense across multiple cases and investigations. The insider notes that Jack Smith presented apparently come from people who were present at key meetings where Trump was discussing his options for challenging the election results and for handling the classified documents after he left office. These aren't random people with an axe to grind based on how evidence like this typically works in federal cases. These are likely notes from lawyers, White House staff, or other officials who were taking contemporaneous records of meetings, because that's standard practice in high-level government operations. When you have multiple sets of notes from different people at the same meetings all saying essentially the same thing, that creates an incredibly strong evidentiary record that's very difficult to challenge or contradict. What makes these notes particularly damaging is that they apparently show Trump was receiving clear legal advice that certain actions would be illegal or unconstitutional. And he chose to proceed anyway, or to find lawyers who would tell him what he wanted to hear. That pattern of conduct, being told something is illegal, shopping around for different legal advice and then doing it anyway, is exactly the kind of evidence that prosecutors use to establish willful criminal intent rather than just negligence or mistake. It shows Trump wasn't just confused or misled. He was actively choosing to ignore legal advice because it didn't align with what he wanted to do. That's much harder to defend than a situation where someone genuinely believed in good faith that their actions were legal. The digital forensics work that recovered the deleted surveillance footage from Mar-a-Lago is particularly impressive from a technical standpoint and shows just how thorough Jack Smith's investigation has been. When you delete video files from security camera systems, the data doesn't immediately disappear from the hard drives. It just gets marked as available space that can be overwritten when new footage needs to be stored. If investigators can get access to those drives before too much new data overwrites the old files, forensic experts can often recover at least portions of what was deleted. The fact that Smith's team was able to do this suggests they moved quickly to secure the relevant devices and had skilled technical experts analyzing the data to reconstruct what had been there. The recovered footage apparently shows people moving boxes of documents in ways that correspond with timing of subpoenas and legal requests, which strongly suggests obstruction of justice. The recordings of Trump's private conversations are probably the single most damaging piece of evidence because they remove all ambiguity about what Trump knew and what his intentions were. Defense attorneys in cases like this usually try to argue that their client didn't have criminal intent, that they genuinely believed their actions were legal, that they were relying on advice from lawyers or advisors, and that any mistakes were honest errors rather than deliberate crimes. But when you have recordings of the defendant admitting in their own voice that they knew something was illegal, or that they were trying to hide evidence, or that they understood they didn't have authority to do something, all those defenses collapse immediately. You can't argue, "I didn't know," when there's a recording of you saying, "I know this is illegal, but I'm doing it anyway." That's the nightmare scenario for any defense attorney. The witness breakdowns during cross-examination revealed just how powerful this evidence was when deployed in real time in a courtroom setting. Prosecutors typically save their most devastating evidence for cross-examination rather than revealing it earlier, because the element of surprise makes it much harder for witnesses to come up with explanations or excuses on the spot. When a witness is sitting on the stand having just testified to something, and then the prosecutor plays a recording or shows a document that directly contradicts what they just said, the witness has to make a split-second decision about whether to double down on the lie or admit they weren't being truthful. Many people in that situation choose to come clean because they realize continuing to lie would just make things worse, especially if they're already facing potential perjury charges for their earlier false testimony. That appears to be what happened here, with multiple witnesses essentially folding under the pressure of being confronted with undeniable evidence that their testimony was false. The emotional breakdowns, witnesses crying on the stand and visibly distressed, are particularly powerful moments in a courtroom because they signal to the judge or jury that something really significant just happened. Experienced witnesses, or people who are comfortable with lying, usually maintain their composure even when challenged. But when someone breaks down emotionally, it often indicates they're genuinely conflicted about having lied and they're experiencing real guilt or fear about the consequences. Those moments tend to be very persuasive to fact finders because they read as authentic expressions of remorse or recognition that the witness has been caught. Defense attorneys hate these moments because there's really no way to rehabilitate a witness's credibility after they've admitted to lying while crying on the stand. The damage is permanent and irreversible. The connection to January 6th planning is significant because it potentially links Trump's actions around the election to the violence and chaos that occurred at the Capitol. If the evidence shows Trump knew his election fraud claims were false, knew he had lost the election legitimately, and still deliberately inflamed his supporters with lies that led to the Capitol attack, that raises serious questions about potential charges related to incitement or conspiracy. The Justice Department has been careful about how aggressively to pursue Trump personally for January 6th related crimes. But if this new evidence clearly establishes his knowledge and intent, it might give prosecutors the confidence they need to bring more serious charges that directly tie him to the violence, rather than just the political and legal maneuvering around the election. The Mar-a-Lago classified document situation is similarly serious, because the evidence apparently establishes not just that Trump had classified documents he shouldn't have had, but that he actively obstructed efforts to recover them. Having classified documents after leaving office is bad, but it's potentially explainable as negligence or administrative error if someone cooperates when the documents are discovered. But when you start deleting surveillance footage, moving boxes to hide them from investigators, and lying to federal agents about what you have, you've crossed from negligence into obstruction of justice, which is a much more serious crime with much harsher potential penalties. The combination of the documents charges plus the obstruction charges creates a really strong case that would be difficult for any defendant to beat, let alone one where the evidence is this clear and comprehensive. The judge's characterization of the evidence as outcome determinative is really the key indicator here of how strong Smith's case has become. Federal judges don't use language like that casually or without having reviewed the evidence carefully themselves. When a judge says evidence could determine the outcome, they're signaling to both parties that the case has fundamentally shifted and that the defendant should seriously consider negotiating a plea deal rather than going to trial, because going to trial with evidence this strong is likely to result in conviction and potentially harsher sentencing. It's a way of telling the defense you're in real trouble here and you should think carefully about your options without explicitly saying that, because judges have to maintain at least the appearance of neutrality, even when they can see which way the evidence is pointing. So what does all of this actually mean for Trump's legal future and for the broader political landscape heading into 2026 and beyond? Let's break down the concrete implications, because this hearing represents a major turning point that could lead directly to Trump's conviction on serious federal charges with the potential for significant prison time. The most immediate impact is that Trump's legal defense strategy has essentially collapsed, and his lawyers are going to have to completely rethink their approach. When your key witnesses have admitted to lying and reversed their testimony, you can't put them back on the stand to help your case. They're now effectively prosecution witnesses whose testimony will be used against you. That means Trump's legal team needs to either find new witnesses who can tell a more favorable story, or they need to shift to a strategy that doesn't rely as heavily on witness testimony and instead focuses on legal and constitutional arguments. The problem with shifting strategies at this late stage is that it signals weakness and suggests desperation, which judges and juries pick up on very quickly. Prosecutors will argue that the reason Trump's defense is changing is because the original defense was based on lies that have now been exposed, and therefore the new defense should be viewed with similar skepticism. It's incredibly difficult to recover credibility once you've lost it in court, and Trump has now lost significant credibility through the exposure of his witnesses as liars. That doesn't mean conviction is absolutely certain. Defendants do sometimes win cases even after suffering setbacks like this, but the odds have shifted dramatically in favor of conviction. For Trump politically, this hearing is devastating because it feeds into the broader narrative that he's a criminal who's finally being held accountable after years of evading consequences for his actions. His approval rating has already dropped to around 36%, according to recent polling, and negative developments like this hearing will likely push those numbers even lower as Americans watch news coverage of witnesses admitting they lied to protect him. Republicans who are already nervous about the 2026 midterms are going to be even more worried about being associated with Trump when there's mounting evidence of serious criminal conduct. You're going to see more Republicans trying to distance themselves from Trump, or at least avoiding defending him too aggressively, because they don't want to be caught on the wrong side if he ends up being convicted. The connection to the House Republican subpoena of Jack Smith is interesting because it shows Republicans trying to fight back against the investigation through congressional oversight and political pressure. House Republicans recently subpoenaed Smith as part of their investigation into what they claim is political prosecution of Trump. But this hearing demonstrates why that line of attack is going to be very difficult to maintain. When you have evidence this strong, recordings, documents, recovered deleted footage, it's hard to credibly argue that prosecutors are just making things up or pursuing Trump for political reasons. The evidence speaks for itself, and congressional Republicans who try to defend Trump too aggressively are going to look ridiculous when prosecutors can point to recordings of Trump admitting illegal conduct. The dismissal of the Georgia case against Trump, which happened around the same time as this federal hearing, is a reminder that Trump does still win some legal battles, even as he's losing others. The Georgia case was dropped due to prosecutorial misconduct issues unrelated to Trump's actual guilt or innocence, but it still removes one major threat from his list of legal problems. However, The federal cases brought by Jack Smith are much more serious and much more difficult to dismiss on technicalities because federal prosecutors generally have better resources and more professional operations than state-level prosecutors. The fact that Trump won in Georgia doesn't really change the calculus on the federal charges, which appear to be on much stronger legal footing. For Democrats heading into the midterms, this hearing is a gift because it provides concrete evidence of Trump criminality that they can point to in campaign ads and debates. Democrats can now credibly argue that Trump is a criminal whose own witnesses admitted to lying for him, and that Republicans who continue to support Trump are complicit in covering up serious crimes. That's a powerful message, especially in swing districts, where voters are less committed to either party and might be swayed by evidence of corruption and lawbreaking. Democrats are going to hammer this point relentlessly. Trump's witnesses collapsed, admitted to lying, and the evidence shows criminal conduct that should disqualify him from office and potentially send him to prison. The erosion of GOP support for Trump that this hearing accelerates is particularly significant because it could lead to a fracturing of the Republican Party between Trump loyalists who will defend him no matter what evidence emerges, and more traditional Republicans who want to move on from Trump and focus on winning elections with candidates who aren't carrying massive legal baggage. That internal division makes it much harder for Republicans to present a unified message or coordinate effective campaign strategies, which gives Democrats a significant advantage in competitive races. If Republicans are spending their time fighting each other over Trump instead of attacking Democrats, they're going to have a very difficult time winning the marginal seats they need to maintain control of Congress. The long-term implications for the American political system are also worth considering because this case is testing whether someone who held the highest office in the land can actually be held accountable for criminal conduct. For decades, there's been this sense that presidents and former presidents operate in a different legal universe where they don't face the same consequences as ordinary citizens, and Trump has certainly benefited from that perception throughout his career. But if Jack Smith can successfully prosecute Trump and secure a conviction based on this evidence, it would establish a new precedent that former presidents can and will be held accountable for crimes they committed while in office. That's potentially a healthy development for democracy and rule of law, even though it's obviously traumatic and divisive to prosecute a former president. The bottom line is that this November 15th hearing was a watershed moment that dramatically increased the likelihood of Trump being convicted on federal charges and potentially serving prison time. The evidence Jack Smith presented was devastating. The witness breakdowns were catastrophic for the defense, and the judge's reaction signaled that the case against Trump is extremely strong. Trump's legal team is now in crisis mode, trying to figure out how to salvage something from this disaster, but their options are limited, and none of them look particularly promising. Politically, this accelerates the decline of Trump's influence within the Republican Party and gives Democrats powerful ammunition for the 2026 midterms. The next few months are going to be absolutely critical as this case moves toward potential trial or plea negotiations, and the stakes could not be higher for Trump personally and for American politics more broadly.